Good afternoon, everybody, and thank you very much for joining our webinar. We're particularly grateful that you've chosen to do so today because it is, after all, half term and it's 3:30 on a beautiful summer's afternoon. So the temptation to sit in the garden with a drink must have been strong. Thank you for joining us now. And if you are watching this on catch up later, I hope you did enjoy your drink in the garden. Right. Title of our webinar is Causation in Clinical Negligence, Common Law and Human Rights Act. I'm going to speak to you about some of the common law aspects, and I'll then hand over to Judith, who will consider some consent causation issues and also the Human Rights Act matters. Before we start, one small housekeeping point, if I may. I know that this webinar was advertised as allowing for Q&A. Judith and I have discussed this, and we think that we've got quite a lot to get through, and this is a rather wet towel round the head subject, and we're not sure it'll help if there are interruptions for questions and answers. But please, by all means, after the webinar, do send your questions to us, either directly to us on email or via the clerks, and we'll do best to help you out. Lastly, before we start, a notice, another 39 Essex webinar is taking place on the 30th of June dealing with causation. That's going to be presented by Derek O'Sullivan, Christian Ducan and Michael Standing. And we do recommend that you watch that because personal injury causation and clinical negligence causation are very interesting to compare and contrast. I think Christian and I may also be doing later in the summer a causation webinar on disease, so that we hope will make the complete set. Right, causation in clinical negligence, why so complicated? Well, the answer obviously is the mysteries of medicine and the human body. We often ask our experts impossible questions, at least impossible for them to answer precisely. Often medicine can tell us precisely why something happened, but just as often it can't. We may have to make do with an educated guess from experts, or we may have to make do with statistical analysis from epidemiologists. Often, of course, we're also asking what would have happened in a counterfactual world, which of course adds another layer of complexity and confusion in many cases.
James, it's Judith here. I think you need to start your video because we can't see you.
I'm very sorry. Well done, Judith. How's that? Right, the starting point for any case. This is the claimant's task in any clinical negligence case. The claimant must prove on the balance of probability that the negligence caused or materially contributed to the adverse consequences complained of. Now, the words to look out for there and to keep in mind as we go through these slides is materially contributed, because they, we believe, are the words that cause a lot of the confusion and complication in these cases. We all know the but-for test, and indeed in many clinical negligence cases it is easy to apply. Let's take an example of a case where it causes no trouble at all. I go into hospital, a surgeon mistakenly removes my right kidney instead of my left. I'm left with one defective kidney. But for the surgeon's negligence, I would of course have had one good kidney. That's an easy one. I succeed in establishing causation. So that's the but-for test on causation at its most simple, and the claimant is not going to have any difficulty in a case of that kind. And there are many cases where precisely the issue is precisely that simple. But many cases we fear are, or at least they appear to be, much more complex. Now, what I've done in the next 15 slides, and I accept I may be accused of some oversimplification, is try to reduce about 200 pages of heavy jurisprudence to about, as I say, 15 slides. But what I've tried to do is set up signposts. So when we read the papers on our new case, we can see straight away down which route we are meant to be going on the case so that we can solve the eventual dilemma of whether it's a winner or a loser. So I've picked some, I hope, easy to understand headings and gone through the leading House of Lords cases in a way that I hope enables you to do that. Let's start then. First one is the injury would probably have happened anyway case. and the leading authority on that is Hodson against East Berkshire, a House of Lords case from 1987. Facts are pretty simple. The claimant was at school and he fell out of a tree and damaged his femur. He was taken to hospital but sent away again. They didn't think he had a fracture. Eventually, he went back to hospital and sure enough, the fracture was diagnosed, but there was, in that intervening period of 5 days, a negligent delay in the diagnosis. He started to receive treatment, but unfortunately, he went on to develop a vascular necrosis of the tip of the femur, leading to permanent disability in the hip joint. He sued the hospital. Now, at the trial, the judge, who was our very own Mr. Justice Simon Brown, as he then was, found that there was a 75% chance, even without the delay, the claimant would still have developed a vascular necrosis. Now, being a fair-minded judge, Mr. Justice Simon Brown clearly thought that merited compensation, so he concluded that the claimant should receive 25% of his damages on a loss of chance basis. The case made its way through the Court of Appeal and eventually to the House of Lords, and unfortunately for the claimant, the House of Lords overturned the award. And the finding by the House of Lords, the key finding, was that it was the fall that was the effective sole cause of the avascular necrosis. Or to put another way, in the context of where I started, the claimant failed to show that the negligent delay in diagnosis was a material contributory cause of the avascular necrosis. Now, I hear you saying, what about the judge's 25%? If the judge found that he had a 25% chance of a good outcome without the delay, how can we say that there was no material contribution made by the delay? Well, the House of Lords simplified the judge's findings in a way that enabled them to reach the conclusion that I've already mentioned. They put a simplifying gloss on the evidence, and what they said was that when the claimant fell out of the tree and landed on the ground, he destroyed so many of his healthy blood vessels that at that point, and indeed when he got into the ambulance, the fate of the hip was already determined. He was already going to suffer from avascular necrosis. The die was cast. Or, as Lord Ackner put it in the House of Lords, the judge determined as a matter of fact on the balance of probabilities that the delay had no effect on the claimant's ultimate condition. So it wasn't a material contribution case, it was a straightforward but-for case. And as I called it at the beginning, it was the injury would have happened anyway case. So what do we learn then from Hodson, just to finish up on Hodson? First, causation of injury remains a matter of proving past fact on a balance of probabilities. And I'm afraid the claimant fails if the evidence shows that the outcome would probably have been the same in any event. So that's Hodson. I hope I've simplified what is quite a long and complex report in a way that is helpful. Next category of case, I've called it the can't say what caused or contributed to the injury case. And the leading case on that is another very familiar one in our field, Wiltshire and Essex Area Health Authority. It's the House of Lords in 1988. C was an unfortunate, claimant, was an unfortunate baby who was born prematurely, and he required a catheter to measure his blood oxygen levels. Now, by negligence, the doctors inserted the catheter into the wrong vein, which meant that the machine was not properly measuring his blood oxygen levels, and he received for a long period too much oxygen. He went on to develop a condition of the retina called RLF, and sadly he went blind. He sued. Now at the trial, it was common ground there was too much oxygen in the blood could cause RLF. But the evidence also showed that RLF could develop for other reasons. So the judge was backed into a cul-de-sac there. There were possible causes, but nobody could point to a probable cause. So the judge found a way around that by reversing the burden of proof. He imposed on the defendant an obligation to show that if the negligence hadn't happened, the RLF wouldn't have occurred. Clever way of getting out of it, but I think we all know where this is going. On appeal, the House of Lords overturned the decision, holding very firmly, and this, as we all know, is the correct expression of the law, that the burden of proof was on the claimant. And here, on causation, the claimant, had not shown that the excess oxygen levels caused or materially contributed to the development of the RLF. So that's a case where the claimant simply couldn't produce the evidence to prove the causation. So again, quite a simple analysis, I hope, although, of course, much of the time we will be finding more robust experts who can produce much firmer opinions, but in some cases, the evidence ends up where it did in Wiltshire. Next one, slightly more complicated, and a real monster of a House of Lords law report. This one's 60 single-spaced pages. I've called it the loss of a poor chance of a favourable outcome case. And by poor, I mean less than 50%. Now, the unfortunate claimant in this case had a lump under his arm. He went to see his GP, but he was told it was nothing and he was sent away. A year later, the lump was still there. He went back and he was diagnosed with cancer. The trial judge found that the delay allowed the cancer to progress more quickly. And the evidence showed that the delay reduced the claimant's chances of 10-year survival, which in this cancer case meant the same or was equivalent to a cure, from 42% if there'd been no negligence and there'd been immediate treatment, to 25% in the event that transpired. But the judge dismissed the claim on the basis that the claimant would not have been cured anyway. In other words, 42% not more probable that he would have been cured, so the claim fails. And off we go again to the House of Lords for resolution of two arguments. Now, in the House of Lords, the claimant put forward two alternative arguments, first of which we see there was rather clever. Instead of saying that the injury was a loss of chance of survival, the claimant said, no, the injury was the faster progression of the cancer, which, as we saw in the facts earlier, did take place. The cancer progressed further across his body. That's an injury. Breach of duty was admitted, so said the claimant. All that's left is compensation, which should include the loss of evaluation of the loss of chance of survival. Secondly, they said, well, actually, any previous cases that have said that a loss of chance of a better outcome or of survival was not a compensatable injury were wrong. So they restated the argument that we've already seen, that loss of chance is in itself a compensatable injury. House of Lords, I'm afraid, rejected both. The first argument, House of Lords said, you can't reclassify the injury to avoid causation. You have to establish causation of loss before you can quantify that loss. Secondly, I'm afraid the House of Lords restated that loss of chance of a favourable outcome is not compensatable damage in clinical negligence claims. And as Lord Hoffman said, everything is determined by causality. Loss of chance does not apply. Now, there was some strong dissenting opinion in Gregg and Scott, and the most outspoken of their lordships was Lord Nichols, who called the outcome irrational and defensible, making the very easy to understand and patently correct point that if this claimant had started off with a 51% chance of recovery, but for the negligence, he would have won. He'd have got his damages. Because it was 44, i.e. less than 50, he can recover nothing. Now, notwithstanding that strong dissenting judgment, Gregg and Scott remains the law. So the loss of chance of a poor outcome, the loss of a poor chance of a better outcome is determined by looking at Gregg and Scott. Now, that was 20 bad years for claimants in clinical negligence cases, you were beginning to wonder how, in a very difficult case, a claimant could ever succeed. But don't worry, because there was light at the end of the tunnel, and that light came in 2008 in the very well-known case of Bailey against MOD. And I've called this the material contribution case. The claimant was in hospital for a gallstone operation. After the operation, she was in a weakened state because of non-negligent pancreatitis. It was just something that developed after the operation through nobody's fault. And unfortunately, the hospital did not care for her properly after she developed the pancreatitis, which caused her weakness to increase. And then there was a very unfortunate sequence of events where she vomited, choked on her vomit because she was too weak to regurgitate it, and she suffered a heart attack, which led to hypoxic brain damage, so a complete catastrophe for her. Now, the judge in that case, our very own Mr. Justice Foskett, you'll be detecting a bit of a theme here, at first instance found that the heart attack was caused by the weakness, which itself had two causes. One, the non-negligent pancreatitis, and two, the negligent care of the hospital. And on that basis, Mr. Justice Foskett found that the hospital was liable. In other words, that the hospital's negligence had made a material contribution. So now we're all thinking, well, how did they get around Hodson? Well, it went to appeal, and the Court of Appeal upheld Mr. Justice Foskett because they agreed that the negligent care made a material contribution to the weakness. And you remember, first of all, there was the weakness, then there was the aspiration, then there was the heart attack, and then there was the brain damage. But the negligent care made a material contribution to the weakness, which in turn was the physical cause of what followed. And here we have to go to the very last page of the judgment, and I'm going to read this out because it is a very useful summary for the law as it is by Lord Justice Waller. And Lord Justice Waller divided his speech into three parts at this stage. First, if the evidence demonstrates on a balance of probabilities that the injury would have occurred as a result of the non-tortious cause or causes in any event, the claimant would have failed to establish that the tortious cause contributed. That's Hodson. We've covered that. Secondly, if the evidence demonstrates that but for the contribution of the tortious cause, the injury would probably not have occurred, the claimant will, obviously, have discharged the burden. So that's rather like my kidney case. And thirdly, and this was the real new fork in the road where the claimant, things got much better for claimants if they went up that route. In a case where medical science cannot establish the probability that but for an act of negligence, the injury would not have happened, but can establish that the contribution of the negligent cause was more than negligible, the but-for test is modified and the claimant will succeed. So Hodson's still in the way if it would all have happened anyway, but if Hodson doesn't apply, the claimant needs to show a material contribution that is more than negligible. And I think we all doing this sort of work have seen just how much that has availed claimants since the decision in Bailey. Many, many cases now succeed that one suspects might have had trouble before Bailey. And lastly, my fifth category I'm calling the more than doubles the risk case. And the leading authority on this, well, it's a first instance decision, it has been discussed in some of the more recent disease cases, is the case of XYZ against Shering Chemical, which is 2002, a decision of our very own Mr. Justice Mackay. And the issue in Shering Chemical, which was a group action, was whether a contraceptive pill caused blood clots. The only evidence was epidemiological. Nobody ever particularly knows for sure exactly what mechanism causes a blood clot. Well, they tend not to anyway. And so what we were reduced to was statistics, and the claimants tried to prove that those taking the pill were at more than twice the risk of a clot than those who were not taking the pill. They couldn't prove that and they failed. So what is the logic of that argument? Well, Mr. Justice Mackay put it like this. If the risk from potential cause A is X% and the risk from the other potential cause B is 2.1x, it is more likely than not that the condition which has eventuated has been caused by B. So you can see the logic of that. If you've made it more than twice as likely that the unfortunate outcome happens, then it's possible to infer that that is what has caused it, the increase in risk. And that's the logic of the more than doubling the risk cases. Now, I hope that wasn't too fast a run through. I've set out some further reading there. Particularly interesting, although again, we're in wet towel territory, you need to concentrate very carefully, that's for sure, is the unnecessary causes article by Professor Jane Stapleton from the Law Quarterly Review, January 2013. Professor Stapleton, I think, accepts the outcome of the decisions in Hodson and Bailey, but is very critical, particularly in relation to Bailey, as to the Court of Appeal's reasoning, and isn't very happy with Hodson either. Also interesting is Mr. Justice Jay's analysis at the end of the decision in Rich and Hull and East Yorkshire, just for the typically Robert J. crystal clear analysis there. And he also considers the Professor James Stapleton article. And then very recently, only in the last couple of months, we have the Court of Appeal decision in Shembury, which is a fascinating case about what to do when one is faced with statistics which appear to be contradicted by almost what is common sense and what one would expect to happen in a particular case in terms of the expert evidence. So worth having a look at that, but I haven't covered them in detail now because we frankly don't have the time, and also because I've tried to keep it simple. So with that, I'll hand over to Judith.
Hello, everybody. I'm just going to pull up my slides. And then... So I'm going to cover two aspects of causation. Firstly, I'm just going to talk a little bit about the Montgomery consent cases insofar as they deal with causation, factual and legal causation. And then I'm just going to talk in the last 5 or 10 minutes about Human Rights Act claims in clinical negligence areas and causation. And I certainly have noticed that I have dealt with a lot more clinical negligence claims pleaded under the Human Rights Act in the last 6 months, and I've probably dealt with more in the last 6 months than I had in the preceding 6 years. I think it's becoming a much more common aspect of claims. So just starting with Montgomery. Now, one aspect of Montgomery that's often overlooked, I think, is the causation aspect of the Supreme Court judgment. So we all know what it says about consent and the way it changed the Bolam approach to consent to implement a much more claimant-friendly test. But in Montgomery, at first instance, the claimant's evidence was that she would have chosen a C-section if the risk of shoulder dystocia sufficient to cause a nerve palsy or severe hypoxic brain damage had been raised with her, and it hadn't been. And the treating consultant, Dr. McClellan's evidence was the same. And the whole reason she didn't explain the risks of shoulder dystocia to the claimant was because she thought that most diabetic women in the claimant's position, so at risk of producing a larger baby with a lot of the extra weight concentrated around the shoulders, most women in the claimant's position would have opted for a C-section. Now, at first instance in Scotland and then in appeal, the courts found that the claimant did not establish factual or legal causation despite that evidence. At first instance, the judge had really made nothing of the fact that Dr. McClellan's evidence had also been that the claimant would have opted for a C-section. And so very unusually, the Supreme Court overturned the first instance finding on causation and the decision of the Scottish Court of Appeal, the Exeter Division, and found that causation was established. So the claimant would have chosen a C-section if the risk had been explained to her. It wasn't a small risk of shoulders dystocia. It was about 9 to 10%. And Dr. McClellan's evidence, which, as I say, had been overlooked at first instance, was that the claimant would have chosen to have a C-section. So on that basis, the Supreme Court overturned the causation finding, and the claimant, as we know, succeeded. It does remain the case, however, that it's highly unusual, as I say, for the Supreme Court or any appeal court to overturn a causation finding on the facts like that. It does remain the case that factual and legal causation are very difficult hurdles for claimants to overcome in Montgomery cases. So just looking, and like James, I'm going to try and keep things simple. There are quite a lot of first instance decisions on Montgomery now, and in fact, Montgomery consent cases have been to the Court of Appeal a number of times. So I'm just going to summarise the position as I now understand it to be. So Diamond and Royal Devon went to the Court of Appeal in 2019. It firmly confirms that the but-for test applies to causation in consent cases. So the claimant in that case had a hernia repair. When she made the decision to undergo the hernia repair and to have a particular form of mesh-based hernia repair, she wasn't told at that point that there was any risk of any problem if she had a later pregnancy. But the surgeon's evidence was that if he had told her about that risk, he would also have told her that, well, sorry, the other option to having a mesh repair was a surgical approach, but the evidence of the surgeon, supported by experts, was that the alternative, the suture-based repair, was possible, but it would have been likely to fail within a couple of years, and that virtually all surgeons would have done the mesh-based hernia repair, which the claimant opted for. Now, the claimant gave very persuasive evidence that she would have opted for the surgical repair if she'd been advised of all the risks, including the risk that it might affect a later pregnancy. But what the judge found at first instance, and this was upheld by the Court of Appeal, is that though she had come to believe that she would have gone for the surgical repair, in fact, at the time, given the advice she would have been given by the surgeon about the risks of the alternative, she wouldn't have opted for anything other than the mesh-based hernia repair, which she had in fact had. So the but-for causation test applied. The claimant has to prove that she wouldn't have consented if she'd been warned differently. You mustn't apply hindsight, and the claim therefore failed. Now, the claimant was also seeking damages for psychiatric injury, but she failed with that on the facts because she couldn't prove that it was the advice that she'd been given in 2011 when she had the hernia repair. She couldn't prove it was that advice that had caused her any kind of psychiatric injury. Now, she also tried another argument, which is that the shock that she had suffered when she was told in 2014 of the risk to a pregnancy, that was 3 years after she'd actually had the surgery. She tried to argue that the shock was intimately connected with the failure to warn her, using Chester and Afshar and a 2017 Court of Appeal case called Correa. And that failed also. So that, again, the Court of Appeal was pretty strict, very strict, that a but-for test applies. She couldn't prove that the psychiatric injury or the shock was connected to the advice that she'd been given, and that claim failed. And you also know Court of Appeal authority Sean Kovacs, which was upheld or endorsed in Diamond and Royal Devon, that simply failing to warn of a risk, which had happened in the Diamond case, failing to warn her of the risk on a future pregnancy of the mesh-based hernia repair, that does not in itself give rise to damages. So the next case that I'm going to discuss is this 2018 Scottish case, vaginal mesh case, which I think is well worth reading if you can understand the Scottish legal terminology, which I have to say I always struggle with slightly. Now, some of you will be aware, I know that some of you are aware, that vaginal mesh litigation, of which there's now a considerable amount in England, but there has already been vaginal mesh litigation in Scotland. It's further advanced than the equivalent cases here. So in 2018, there were 4 decisions on 4 lead cases. A lead case approach has been adopted in the Scottish vaginal mesh litigation. And there was judgment in this AH and Greater Glasgow Health Board on some preliminary issues that were raised, thrown up by those 4 lead cases. Now, it's all about consent, basically. Would the claimants have consented to the vaginal mesh surgery or treatment that they'd had if they'd been advised of the risks as they obtained at the time when they actually had the procedures? Now, what the judge said was that no claimant of the 4 that he was considering had specified what alternative treatment she would actually have gone for. Well, firstly, she hadn't specified which alternative treatments she said were reasonable. They simply set out a lot of different alternative treatments. And no claimant had specified which of those alternative treatments she would actually have gone for if she'd been differently or properly advised. And the judge took a firm line with those cases and said, if you don't plead, and you haven't, which alternative you would have taken if you'd been differently advised, then the case can't go forward. You have to plead and then prove which alternative you would have taken. So the cases are only going forward on the basis that if the claimants had been advised differently, they would have taken not any alternative treatment, but would have opted to have no treatment at all. So I would take from that if you want to run a Montgomery, I would have gone for an alternative treatment case. You have to be very clear in pleading what alternatives were open to the doctors to give you at the time when you had the procedure, and you then have to prove that as a matter of fact. Now, the claimants tried to argue in AH and Greater Glasgow that it wasn't necessary for them to do that. The court could simply draw inferences about the alternative, and the court gave that argument short shrift. Now, the cases of AH makes it absolutely clear that, in fact, factual causation is more difficult than that. And I would, again, as James said, these are really wet towel around the head cases. And so I would commend this to you as something to go away and look at. What the judge looks at is the fact that there are 2 lines of cases taking different approaches to explanation of risk in Montgomery consent cases. So there's one case called Moyes and Lothian, which he discusses, where the claimant, she had a stroke when she was having angiography, and she had been told about the general risk of stroke, but she hadn't been told about the special risk which attached to her because she was hypersensitive to the contrast medium. It wasn't, in fact, the hypersensitivity that caused the stroke, but in that case, she won because there were several contributing factors to the stroke which she in fact had, and the combination of those factors led to an increased risk of that stroke happening. So it's a cumulative risk case, and she therefore got home. And the judge in AH draws a distinction between that and an Australian case called Wallace and Cam, where there were 2 distinct risks. The claimant had surgery, and he was warned of the risk of neuropraxia, and he was not warned of the risk of paralysis. Now, in fact, the risk he had been warned of eventuated neuropraxia, but he contended that because he should have been warned about the risk of paralysis, and he wasn't, he should get damages for the neuropraxia, although he had been warned of the risk that he might get the neuropraxia. And really applying, I think, policy considerations, the Australian High Court, and they looked at Chester and Afshar, said it was not appropriate to extend the scope of liability for one risk to the other risk which actually eventuated. So could he recover if he underwent the procedure and he'd been warned about the risk which in fact eventuated, no, he couldn't, because otherwise you are extending liability too far. The policy behind these cases is to protect the patient from the occurrence of a physical injury, the risk of which is unacceptable. It is not to protect the right to choose or to protect the patient from all possibly unacceptable risks. So that's quite a restrictive analysis of what risks you have to explain to a claimant in order for a claimant to be able to recover damages. So you might succeed on breach, but you won't recover on causation in those circumstances. Now, what the judge said in AH was, it wasn't quite clear in these vaginal mesh cases whether it was a cumulative risk case or a separate risk case, like the Australian case I've just discussed. Not every case can be compartmentalised as easily as that. And you would have to see when the cases actually came before him for a full decision. So the policy question, which does clearly emerge from that AH decision, is the risk which was not explained to the claimant a risk for which he or she should be compensated? And I think that underlies a lot of the decisions which have followed from Montgomery. So that's, I think, all I'm going to say about, I've set that out on the slides. I think that's all I'm going to say about the Montgomery line of cases. So just to endorse the basic point, factual causation has to be pleaded, it has to be proved, and you have to prove that the risk that wasn't explained to you was a risk which eventuated. So I'm going to come on then in the last few minutes just to talk about HRA damages in clinical negligence scenarios. Now, you'll be aware, and I've set this out on the slides, that Section 8(3) of the Human Rights Act, and this comes straight from the Convention of Human Rights itself, says that you won't get an award of damages, and there is a typo in the slide, which you've probably spotted. You won't get an award of damages unless, taking into account all of the circumstances, including any other relief or remedy or order, and the consequences of any decision in respect of that act, the court is satisfied that the award is necessary to afford just satisfaction to the person in whose favour it is made. So that's quite a long provision, but what it basically says is there is no right to damages. So contrast the position at common law, obviously, whereas if you establish a breach and causation, you would get damages. Contrast that position to the position under the HRA, whereas even if you establish a breach of one of the articles and causation, you will not get damages unless the court is satisfied that the award is necessary to give you just satisfaction. So that's a high test, necessary and to afford just satisfaction. And you will see that one of the things the court looks at is whether any other court has afforded any other relief or remedy or order. So looking first at Van Colley, the reason I have given you this quotation is just to show that from an early stage after implementation of the Human Rights Act, so that was Greenfield in 2005, which is then approved again by the House of Lords in Van Colley and Chief Constable. Convention claims have very different objectives to civil actions. Civil actions are all about compensation, and convention claims are intended rather to uphold minimum human rights standards and to vindicate those rights. So compensation is not the primary aim of a convention claim. So in Van Colley, it was a police case, and the principle of police immunity remains at common law, as you know, but an Article 2 breach is possible. You can have Article 2 damages if the police fail to do their job properly in protecting life under Article 2. So you can have a separation, no damages at common law, there can still be immunity, but you can recover under Article 2 if appropriate. Just looking again at this slide, breach but no damages. In Greenfield, it was an Article 6 case. And one thing I should emphasise is that obviously most of the clinical negligence cases will turn on Article 2, Article 3, or possibly Article 8. And you have to look at the question of whether damages are likely to be awarded on an article by article basis, really. But in Greenfield, it was an Article 6 case, and the claimant argued he was a prisoner who hadn't been given due process when a prison investigation was carried out. He hadn't been given the right to legal representation. And he argued that because his Article 6 right to a fair hearing had been breached, he should have damages, and compared the situation with tortious damages. And the House of Lords in Greenfield had really no hesitation in saying that in most of the European Court of Human Rights cases, you don't get damages for breach of an Article 6 right if you've not really lost any chance of a better outcome. And in Greenfield, he couldn't prove that he lost a real chance of a better outcome, so he got no damages. So losing the real chance of a better outcome does begin to show you that although you have to establish causation, and I'll look at this in a little bit more detail in the next slides, you don't necessarily have to establish causation in the 51% but-for way that you would at common law. But situations in which a claimant may not recover damages under the Human Rights Act are, for instance, where you get a declaration that there's been a breach. So that's the Greenfield situation as I've just described it. But looking at the common law Clyn-Neg cases, if there has been an inquest, for instance, and the coroner has sent a Regulation 28 letter after that inquest, or if common law damages have been recovered, or both, then that may be a situation in which damages will not be awarded, looking at the stringent Section 8, subsection 3 test. Another example that I've given you is this 2007 case of Re P. So this is a case where the claimant's child had been removed into care. The local authority had very clearly breached its duty to consult her when it removed her child into care. She should have been invited to a meeting, and she wasn't. But crucially, the removal had been lawful. The claimant at the time wouldn't have had the emotional capacity to participate in the meeting, and the local authority had kept her solicitor involved. So that there was a declaration that there'd been a breach, but that was enough for just satisfaction, and she didn't recover damages. Now, just looking swiftly at two further cases. So DSD and Commissioner of Police for the Metropolis, this is one of the John Warboys awful rape cases. Now here, just so that you're aware of this line of authority, the victims of John Warboys that had damages from John Warboys himself, and also money from the CICA, but that wasn't a bar to separate damages under the Human Rights Act because the police's failures in investigation had been so egregious that it was necessary to make the police pay damages under the Human Rights Act in order that standards be upheld. So that's an example where you could argue, it was argued that there'd been just satisfaction, and that didn't get the police anywhere. Just looking at Halford, I'm running short of time, so I'm just going to skip over this very quickly. The claimant in that case, it was a phone tapping case. The Assistant Chief Constable's own phone was tapped by the police. She did get damages for that, but less than she might have done because it wasn't absolutely clear what or how the police's phone tapping had led to the stress that she'd suffered. The case which I do want to emphasise to you, it's a fairly recent case of 2014, and it's decision of Lord Dyson in the Court of Appeal. The claimant had been attacked, as I said in the slide, by men with baseball bats. There had been a slow response by the police, and the claimants claimed under Article 2 and Article 3 of the HRA. What Lord Dyson said was that there was a breach of Article 2 and 3, this was what was going to go on to trial. He was being asked to make a decision at the preliminary issue stage, but a finding that a response would have made no difference may mean that there is no right to damages. So in causation terms, if you can't establish that if the police had done what they should have done, that they would have managed to prevent you being attacked, you may get a declaration that there's been a breach, but you will get no right to damages. So important for both claimants and defendants to be aware of that. In order to get the compensation, probably do need to show causation under the Human Rights Act, but I took you back in the early slide to Fancoli, where you see that proving as a claimant that you have lost a chance of a better outcome may be enough for the court then to award you damages under the Section 8.3 test. If you can't establish causation, likely that you won't get there. But there are other factors which may mean that you won't get there anyway. I think that's all I want to say about causation under the HRA. I hope the slides are helpful. And with that, I will just hand back to James to say a few concluding words.
Yes, thank you very much, Judith. That was excellent. And thank you very much, everybody, for listening. I hope that was helpful. As you no doubt learned from the email notifying you of this webinar, it's available to watch for the rest of time, I think, on the Chamber's website. So if there are parts that you think you could benefit from watching again, then please do. And as we say, if you have questions, please direct them to us either directly on our email or via the clerks. So everybody can now go outside. It's still a lovely day, 25 degrees my thermometer says outside. So do have enjoyable rest of the day, and thank you very much for joining us on this webinar.